Very close to the exam, NLS has released another sample paper. The second set of sample paper has been released, and we are here to discuss the same in today's video. Hi guys, I'm Ayushi, your mentor for law entrance exams, and welcome to Law Digest. So here we'll be discussing the paper. I won't get into the details of the answers for part A because the answers and the rationale is already given. I will not waste your time and I will simply proceed to the most important parts that I want to discuss with you. Now in part A, as you see the passage, here the passage is basically based on the way how judiciary is being digitized. So this is what the passage essentially deals with. In fact, in our mock number 5 that has been recently released in our mock test series, we have also picked up the same issue of digitization of court practices, and therein we've provided some questions in this say on the same issue only. Here if you will see, question number 1 relates to basically phrase digital divide is used to express what. This question pertains from the English background. Here you already see the answer, the rationale is already given. Now coming on to question 2, this relates to legal reasoning, and this is what I want to discuss with you. I will just discuss the legal reasoning questions with you because for the others you can very well understand. The answers are already given, it can be inferred from the passages, and the rationale is also given. But in these questions, although the answer is given and the rationale is given, I would still like to discuss this with you because I want you to understand some concept as to how you should go about solving these legal reasoning questions. Now, here they've said there is a new law that is called Equality in Access to Justice that has been introduced. Now, Section 3 of this Act says that all litigants before the High Court must be provided the opportunity to present their arguments. And it is the duty of every court to ensure that any litigant who does not have access to the internet or computer is not prevented from being able to present their arguments before the court. So this basically is talking about the fact that if the litigant does not have access to the computers, he should not be prevented from presenting the arguments. Now here what happens is that a litigant called Bijoy, he has filed a case against Sumera in relation to property dispute before Orissa High Court, and the matter is pending before the High Court, and COVID comes in. The matter was thereafter heard through hybrid hearing system because of COVID, and the matter is still pending before the High Court in February. Bijoy has never used the internet, and he insists that his lawyer appears in person before the court. Sumera ka jo lawyer hai, the other side lawyer, appears before the court through video conferencing. But Bijoy says that it puts him in a disadvantageous situation and it violates his right under Section 3 of the Act. And he argues that the matter should not be heard through HS. Now, what is the most accurate? So here, if you will first understand the situation, this situation basically says that somebody who does not have access to the computer should not be prevented. Here the situation is that Bijoy has access to the computer, but that he has never used internet before, and he feels that it can cause him some inconvenience, although he has a lawyer who will appear on his behalf. So the lawyer needs to appear through the computer through the HSS mode. If you will see option A, it says HSS does not deny a litigant the opportunity to present their arguments before the court. Rather, it ensures litigants' presence for the arguments of whether their lawyer appears in person or through video conferencing. So the lawyer is not being stopped. Here Section 3 is not being violated because lawyer is not being stopped from giving arguments. Merely inconvenience as to the non-usability, that is not used internet ever, does not stop his lawyer from arguing the case. The lawyer can appear in person with Bijoy and operate the system and present his arguments. He is not being stopped. Rather, he is being encouraged through video conferencing that nothing is stopping him. Here also, if you will see the rationale, they've said There is nothing in the passage or in the question to support the claim that lawyers who appear through video conferencing can take advantage of better tools than the other person. So here now in option B they've said his basically apprehension is that the other party's lawyer will use better tools. He can take advantage of the better presenting tools. That is not the case. The case is that you should not be stopped from presenting your argument. So this won't be the case. Then again, if we see this one, then HSS was introduced after the case has been filed and therefore it cannot be used. This is also not the case because the rule, the section does not anywhere say that it will apply prospectively or retrospectively. So we will, here you are seeing that how we are coming to the answer, we are just sticking to the law. Section 3 जो कहता है हम उसके basis पे decide कर रहे हैं, we are deciding on the basis of this only and obviously the passage in consonants and the facts. Then again, if you will see here it says HSS ensured that judges could continue hearing the matters during the pandemic, but its use should be discontinued after the pandemic is over. Here the matter is being heard when there's a pandemic, the pandemic is on, it is then when the matter is heard. And it says that Bijoy's right will be violated only if HSS is continued after the pandemic. This is not the situation. Here, if you will go by the law does not anywhere speak of the pandemic. Here it is being said that it is an opportunity that is being given so that people can use internet to make use to present their argument. So this also will not be the answer. Option A is the correct answer here. Then moving forward here, this is about inference. This is critical reasoning. Then AI driven research portal launched by launched for judges. Answer is Supreme Court portal for assistant SUPACE has been launched. This is a current affairs question. This is a legal current affairs question. Legal current affairs we've been doing from very long. We've been covering that in our module as well as in our YouTube videos. I hope you watched our revision series videos on legal current affairs. Do watch that just in case you haven't, because you might find certain questions there. Then which of the following will weaken the argument? Again, critical reasoning. This can be done easily. Again, National Health Survey data, which of the following statements is most accurate? This is your current affairs question. Moving forward, summary of the passage, English critical reasoning you can say, and summary. So you have to choose the option. If you find the more than one correct options, then choose the option that is the most closest to the summary of the passage. Then chairperson of E committee. This is also legal current affairs question. Justice D.Y. Chandrachud is the correct answer. Then here most accurately describes the difference. So this is again your English critical reasoning. Coming on to passage B. Here in passage B again we will move on to this is basically the passage. This relates to sports. Now here this is all critical reasoning, current affairs. Here you see current affairs has been asked up till March as well. So make sure that you've done current affairs up till March. Now because the examination is in another week and it is not possible that they will really ask you current affairs for April. Now here again passage using metaphors. So this is English. Indian women to win Olympic gold medal. Easy current affairs. This is sports current affairs and it's easy. Then again arguments accurately describes, critical analysis, current affairs, critical no, this is your English vocabulary. Then this is current affairs. Now coming on to question number 9, this is your legal reasoning. Here what they've said is they've said that they've in order to promote sports, a scheme has been launched for marginalized communities. This is the rule. The government has launched certain rules. What are the rules? Rule 2 क्या कहता है? It says only athletes who belong to marginalized communities identified in the rules may be selected as the member of the team. Then second, जो लोग marginalized community से नहीं है, they will be disqualified from participation. And third, that you can prove that you belong to marginalized community by producing a certificate to that effect, which is to be signed and stamped by DC. So these are the three rules. These are the laws that you have to stick to. Here the question is, Purnima has been chosen for inclusion in the cricket team to compete in the tournament. On the day of the tournament, organizers tell Purnima that she cannot participate in the tournament since she does not belong to marginalized community as per the list, and she is not a good player. Now we have to tell what of the which is the statement that is most accurate. Here you will read the first statement, can produce a certificate, correct. Here the rule says that you can produce a certificate to show that you're not marginalized. Here if it's the committee is saying that you're not marginalized, what is the remedy that she has? She can produce the certificate, so this part is correct. And if she cannot, and if she does, she cannot be prevented by organizers from participating in the tournament. This can be adjudged from this rule 2 sub rule 3. So this statement is correct so far. Let us see more statements. If any of the statements is closer to this statement, Purnima can produce a certificate which says that she is a marginalized. So this is also part 1 is correct. However, even if she does, she can be prevented from participating on the grounds of performance. Here, this cannot be correct because in the rules, nowhere do we see that performance is a parameter for declining the membership. So we will just stick to the rules. This cannot be the answer. Then the third one is tournament organizers should have scrutinized the players list in advance and they cannot raise objection on the day of the tournament. Now these are all these arguments might come to your mind as a layman, but here in legal reasoning questions we have to stick to the rules only. The rules nowhere say that any such thing is there that you cannot disqualify on the day of tournament. So this also will not apply. Decisions regarding who cannot be allowed to participate in a tournament are taken by DC. Purnima and tournament organizers should therefore approach DC, who should hear out both. No, here it is not the DC who will decide. It is just the DC is, what is he doing? He's just signing and stamping the certificate. He is not deciding as to who will participate or not. So this is also incorrect. The answer is option A only. So here what I basically wanted to tell you is that you have to stick to the rule, even though you might read the options and you might feel that on the basis of common logic, you might feel that other options are correct, but just stick to the rule that is given in the question. Here, this is regarding again inference. So this is your this is your critical reasoning question. Part B, legal aptitude. The sad part here is that again they have not provided us with the answers, that how are we supposed to write answers for these questions. Although 2 more questions have been given to you to give an idea as to what kind of questions can be asked. Now in the mock test series also you will find these kinds of questions, although the length might vary, but however whatever length here they've given, it is on the basis of facts. They've expanded the facts and that is why your answer will expand. We have kept the facts to be less because we had less of time and we wanted the students to practice. In case you are able, if this is the length of the question that we've given and still you're able to give the answer in 5-6 lines, you have so many reasons to quote, then it is very good. You've practiced things well and you will do well in the paper because it's more about reasoning. Now, when we look at these questions, let's look at the first question. I'll tell you the arguments that can be from each side. Here, this question basically deals with the fact that Bhanu Priya, she's a government employee and she has been running a probation period of 6 months. Her employment started on 1st of September. So the 6 months that should end will be on 28th February. Right, and here it says that during the probation she can be terminated without any cause and with immediate effect, the employment can be terminated here. What happens thereafter is that on March 1, she's attending a meeting and she's been asked to take minutes of the meeting. During the meeting, one of the officers makes certain remarks against another employee who's a Christian. Mr. Rao does that, and Bhanupriya, she feels that this is unfair, and in order to show her disapproval of against that employer, what she does is against that senior, she stops writing the minutes of the meeting, and what happens is that Mr. Rao gets angry. He shouts at her that how can she do such a thing. Then he calls her. He does not continue the meeting any further. He calls her to a cabin. He says that this meeting has been jeopardized because of her and he's terminating her services. Bhanupriya asks him to calm down and she tries to defend herself, but Mr. Rao refuses that and he asks Bhanupriya to leave his office and issues an order for dismissal of service. Now Bhanupriya, she raises a complaint against the order of dismissal. What will be the answer? If you are appearing for Bhanupriya, what can be your contentions? First of all, I would like to say that since in the always read the response guidelines, sample paper 1 has those response guidelines. Just in case you haven't read up till now, although I've discussed many a times, they say that you have to identify key facts, key norms. Norms is the law. Key facts, key norms, and then you have to give your reasoning. Now here, there are two ways in which you can do that. Key facts may, what you can do, either in bullets you can write down the key facts. Key fact number 1 will be that here the key fact is not the fact that she's working with PWD. The key fact is that she started her services on September 1, because PWD we see here there is no law as such relating to government employees that has been given, so that is not such a relevant fact for us. Here date is important because her services can be terminated. What is the norm here? The key norm is that contract can be terminated during the probation period without any cause. Then second key fact is that she was asked to take minutes of meeting and she did not, and in the middle of it she stopped taking those minutes of the meeting. The another key fact is that the senior made remarks against an employee based on the religion. Then another thing can be that she goes, the officials has this contention that she has jeopardized this meeting due to her behavior. So all these are key facts. Key facts do not relate to small things, like the fact that Mr. Rao shouts at Bhanupriya asking her to mind her place. This might not be a key fact, because when we look at the reasoning, when you try to frame the reasoning in your head, you will see what are essentially the facts that you've taken into account for in order to form your arguments. So here the arguments from her side can be, first of all, that her 6 months they're getting over on 26 February. So as on March 1, she is a permanent member and she cannot be dismissed without any cause and with immediate effect. She cannot be dismissed like this. Secondly, that she is an employee and she's entitled to express her disapproval with the practices that are being followed. Then again, if Mr. Rao was so bothered by her, then he could have asked someone else to write down the minutes of meeting rather than barging out of the meeting and not continuing the meeting. If that meeting was so important for him, then he should have continued the meeting, telling some other person to write down the minutes, and then later he could have spoken to Bhanupriya as to her behavior. Then it is not Bhanupriya who jeopardized the meeting, it is Mr. Rao who jeopardized the meeting because of his temper issues. Then further, if employees are asked to respect the senior officials, being an employee they're bound to respect. It does not mean that they will agree with each and every point they're making. They have the right to express their disapproval. So these can be your points from the side of Bhanupriya. If you're appearing for Mr. Rao, you have to choose one side only. Either side can be correct as they've sent in the response guidelines. You do not need to defend both the sides. Or you need not think what can be the correct answer. Is Bhanupriya correct or is Mr. Rao correct? You can choose any side freely. What can be the arguments from Mr. Rao? He can say that, if the contract says that it is for 6 months, even if you say that probation period is over, but then in during the probation period you can remove the person without any cause. Here Mr. Rao has a cause that her behavior caused embarrassment to him during the meeting and the meeting could not be continued, and that is why he has issued this dismissal order. Then secondly, Bhanupriya was given the task to take down the minutes of important meeting that was chaired, and if she does not do so, then she is not performing her duties. This can be another cause for expelling her, that she did not perform her duties. Then further, it can be said that if Bhanupriya wanted to express her disapproval, she could have simply interjected after the meeting and made a remark or approached Mr. Rao personally rather than interrupting the meeting in between. Being an employee should have been considerate of such factors. So these can be your arguments for Mr. Rao. If you've tried to solve this paper and these arguments came to your mind, then this is well and good. And if you have any additional argument that came to your mind, then also it is very good. And you might just fetch good marks for yourself in the examination. Second question relates to the fact that Salim has a savings account bank with this particular bank and he regularly used the ATM of this bank to withdraw money. Then later what he sees is that there is another ATM that is located 50 meters away from the bank, and he was suspicious because the logo and branding looked different. So he approached the bank officials, he called up the customer care and he told them that this is I am suspicious about this ATM that is opened up, and the bank said that they will look into the matter. Now, since Salim did not hear back from the bank in 6 days, he thought nothing is wrong. He went to the bank, withdrew money, although there was an error message that appeared and he could not withdraw the money. Later what happens is that a large amount of cash was withdrawn and larger than the bank's daily permissible limit has been withdrawn, and Salim was really shocked that he did not authorize such withdrawal. He reported this incident to the police. He told the customer care representatives. They did not help him. The police took an investigation and they found out that there was a fake ATM that was set up, and these people were stealing information from the cards. Now Salim wants the bank to compensate him for this large amount because many people were cheated, and here it is asked that should the bank compensate Salim. Now here you can take either side as discussed earlier. You can appear for Salim or against Salim for the bank. Relevant facts can be the fact that relevant fact for you will be, first of all, that Salim was suspicious of the ATM and therefore he reached out to the customer care helpline, informed them, and they did not get back. Now reasoning here can be what? Reasoning can be for Salim that he was so cautious that he even checked the logo and it was a new bank. Being a cautious customer, he approached the customer care helpline. He told them what is the issue. It was the helpline, the bank, that did not take care of it. If there is a ATM in the vicinity, they should have known this. They should have taken due care of the new ATM, which is just 50 meters away, and they should have taken this due care of whether the customers are being cheated or not. What is the issue with the new ATM? Is this proper or not? It was their responsibility. Bank has been negligent on both ends. Firstly, they did not inform Salim. Secondly, they did not take care of the ATM, whether it is correct or not. Then further, they have also been negligent on the issue that the amount that was authorized by Salim for withdrawal, the withdrawals have exceeded that limit. How could it happen? Banks should have taken care of that as well. How did they allow a withdrawal more than what has been authorized? So here the bank will be held liable. Now, if you're appearing for the bank, your contentions can be that bank is supposed to take care of the matters that is within the premises of the bank. They cannot be concerned with the areas around what is happening around. It is not the responsibility of the bank to take care, rather it is the responsibility of police to check all of this. The bank is not supposed to physically go and check, the employees are not supposed to go and check this. Then further, the bank, if they told him that they will suspect and look into the matter, then nowhere did the bank say that they will get back to him. So the bank did not had a responsibility to get back to Salim. Although it might appear vague to you in the normal layman language, however, we have to stick to the facts and principles in the question in order to answer such questions. Then another thing can be that for all the frauds that are happening, bank cannot be held liable because there are so many frauds that are happening, and this fraud is not happening because of the bank. So bank cannot be held liable for any third party intervention. This is a total third party intervention, that such a big fraud is happening. The bank is not responsible for any act that is done by the third party. The customers have to be aware of these things, and if the bank did not respond or did not get back to Salim, then he should not have gone to the ATM to withdraw money. He could have approached the bank to help them. He could have visited the physical premises of the bank. Then moving forward, also when he saw that he is not able to withdraw, he should have again gone to the physical premises and reported this issue that he is not able to withdraw money. These can be your contentions from the side of the bank. Now coming on to essays. Here again I would say that although they've said current affairs essays, as you've noted in the modules, we've provided you with static essay as well. If you see part 3, this is a static sort of a concept. This does not relate to current affair. Do women hold key to sporting glory in India's immediate future? This is not current affairs. You have to relate it to current affairs. How can you relate it? You can bring down Olympics, Paralympics, women who won the medals at these forums. You can talk about those things. So that is how you can make an essay on current affairs. Here, this is related to census. Another census took place recently. This is caste census. Again, you can speak about reservation, Maratha quota, these things. Legal current affairs, again, I'd say it's very important. Do watch my videos. In case you're not a part of the modules, do watch the videos for getting a hang of these legal current affairs as to what all legal current affairs can come up. Ukraine war, this is clearly a current affairs question. Again, for essays, I would like to tell you that how are you supposed to write an essay. I've made a separate video on this, but still I see in the mocks that people are not following the guidelines that have been told by me, or if I'm giving them less marks, they have these queries that why, what can they do about the essays. Firstly, you need to give an introduction. How will you do that? When you read the topic, try to identify the keywords and explain those keywords. Here the keyword will be caste census 2020-2011. You can talk about what is a census, what does caste census imply. Then you can further give further details on the census, that it is conducted in every how many years it is conducted, and other things relating to census, how it is helpful, what is the importance of census. You can discuss all of that. Then you can discuss what are the problems that are coming up, what are the issues relating to caste that are coming up. Here in problems, you can bring down current affairs. Quote 2-3 examples from current affairs in order to show that you are aware with the current affairs. Then once you've given the problems, then suggest what is the way forward, suggest a remedy to the problem, and give a one-line conclusion. That is how you are supposed to write your essay. These are the guidelines. Watch my separate videos as well on all of this, and I hope you're clear as to what kind of paper will come, and you've practiced well. Just in case you're looking forward to practice more questions and you've not enrolled for our mock test series as of now, you can do that. It is available on our website www.lorddigest.in. There are in total 5 tests that are available to you. There are unlimited attempts. Try to solve these questions. I've also given you sample answers for part B as to how you can write these answers. So when you'll give the mock, I'll be analyzing them. I'll be giving you marks on the basis of your answers, and you can basically judge how well you have performed. I won't take any longer, and I'll just end this video here. Keep preparing. Just keep yourself motivated. It is all very reasoning based. If you'll see this paper, it's a very reasoning and current affairs based paper. So I hope you've done all of that. And just in case you're lagging behind, I would say watch my playlist on legal current affairs revision series and current affairs playlist. Just in case you feel that you're lagging behind, these playlists will help you with the questions, because at last moment it is not possible for you to get into detailed current affairs and legal current affairs. So this is what I would suggest, and mock tests are already there. All the very best to all of you. Keep following our channel, because we'll keep coming out with more videos that will help you in your law entrance exams as well as your legal career. Also keep following us on Instagram for daily updates.